All right. Well, welcome everyone to today's webinar, Got Failure to Launch Children. You might want to consider using trust incentives and protections. In this webinar, Ms. Noelle Minto will discuss the best ways to draft a trust to address failure to launch children and other beneficiary concerns. This will be a practical discussion of an estate plan can include smart incentives and punitive terms to offer solutions to family struggles, even from beyond the grave. A 2019 study found that young adults whose parents were both supportive of their independence and responsive to their needs had more positive outcomes, such as better academic engagement, less delinquent behavior, and lower levels of depression compared with children whose parents were uninvolved or too controlling. But the question is, how do you find the line between those two extremes? Today, Noelle will discuss key estate planning clauses for children and other beneficiaries who may need extra incentives and protections in order to foster their growth long after you're gone. And with that, I have the pleasure of introducing Noelle. Since 2003, Noelle has been an estate and business transactional attorney based in Orange County, California. Her practice represents high net worth individuals and privately held business entities based throughout the United States and abroad. Noelle has assisted clients in crafting comprehensive estate plans and maintaining business structures to address each family's specific needs, including everything from revocable trust to the formation of charities, including public charities, private foundations, and a myriad of other estate planning tools, which may include qualified personal residence trusts and land trusts, family limited partnerships, buy-sell agreements, intentionally defective grantor trusts, and many other tax-saving and asset protection vehicles. Once an estate plan is implemented, Ms. Minto and her team continue to support clients with any ongoing compliance and coordinate with each other's circle of advisors. When needed, the firm facilitates annual family meetings, corporate maintenance, and assisting with transitional time periods brought on by retirement, incapacity, liquidating events, and ultimately administration upon the death of a settler. As a seasoned estate and succession planning practitioner, Noelle provides guidance and comfort to trustees and beneficiaries of the decedents after their passing and throughout the trust administration process, and assistance in transitioning family business interests. Noelle has a long-standing relationship with various national bank trust divisions who bring her in to provide estate planning services for their private wealth clients and work alongside their skilled teams to ensure the clients have carte blanche, white glove service, and all of the legal services being delivered to those who are typically generational wealth clients or successful business owners. Noelle was selected as Southern California Rising Star by Super Lawyers in 2008 and 10. She speaks Italian, Spanish, and French. She sits on 2 charitable boards in Orange County and is the past chair of the business and corporate section of the Orange County Bar Association. Her firm was incorporated in 2006 and is dedicated exclusively to the fields of trust and estates and business planning. With over $1 billion of assets planned for and protected, Noelle and her team have positively represented hundreds of families and generations. And with that, I have the pleasure of introducing Noelle Minto.
Well, good afternoon, everybody. And it looks like with that introduction, we're about halfway through the lecture time. So I promise to be just about as fast. We're going to be talking today about how to plan and incentivize for our children's growth, even from the grave. And One thing my clients have in common, whether they're wealthy or of average means, is worrying about their children's development. And money, we've learned, can be a hindrance or it can be a helpful tool. And we're going to be discussing today really how to devise our estate plans to include some of those helpful tools. My grandfather always told his 4 children that they were going to receive nothing from the family estate and that it was all going to charity. And, the reason I think he did this was to set up expectations. And he set up those expectations during some formative years. And I think he really was trying to impact their psyche to have the children understand that they needed to stand on their own 2 feet. So even if his promise or threat, depending on how you look at it, ended up not being true, at least they believed it to be true at that point in time, which ensured that he had 4 independent and successful children. Now, going to just really starting with the common trust language that you see. So typically, if you go to a one-size-fits-all type of, maybe an attorney who doesn't practice in the field of trust and estates, or maybe if you are looking at a trust that's really simplified, all you'll see is the language here, right, on principal and income distributions. And it just says, our trustee shall distribute to the beneficiary as much of the income and principal of their share as our trustee determines necessary or advisable for the health, education, maintenance, and support of our beneficiary. Well, that certainly gives a lot of flexibility. It is totally discretionary in the discretion of the trustee, whomever that person may be in the future. But it also sounds like it could potentially be an endless allowance for the beneficiary. Now, of course, this sort of depends on the trust's resources and the trust cash flow, as well as the will of the trustee to maybe give in to the beneficiary or to interpret those words. So a lot of times this just isn't sufficient if we have a circumstance outside of maybe, hey, I'm 70 years old, I have 2 PhD children who are financially successful, well-balanced, have no spouses of concern, and I'm comfortable just giving them complete discretion to take this money out how and when they see fit. Well, congratulations if that's you, but I know that that's not a lot of my clients. And perhaps it might be them someday, but until the children are sort of fully developed, a lot of clients want to do a little additional safety network to make sure that there is a barrier between the money, if they were to pass away, and their children. And so keep in mind, the advice today that I'm going to be giving is based on family needs, and it's not necessarily going to be based on the most tax efficient way to access distributions. So keep that in mind. Now, some of you might remember a movie called Failure to Launch. It came out, Matthew McConaughey was a 30-something kid that was a little too comfortable in his parents' house. And I'm going to show you just a scene basically demonstrating how his parents were ecstatic because they thought they were finally going to launch him out of the home and get him to stand on his own 2 feet. And if we can just see this clip, we can see that's not exactly what happened.
I'm saying is, it is time for Trip to spread his wings.
Wow. Well, this is very unexpected.
So here's the plan. All right, we're gonna blow out the east wall of my bedroom, enlarge the bathroom, basically turn the entire upstairs into a secondary master suite. So there's room for the both of us and the both of you under the same roof. What do you say?
Okay. Well, we all as parents can probably agree that that's not exactly what we're looking for, right? We want to at some stage see our children launch into full adulthood, which we may interpret as independence and success and ability to live in their own home and manage their own home and so on. So today I really want to focus on what carrots and sticks we can offer in our trust documents to ensure that if we have a child like Matthew McConaughey in that movie, we encourage them to take steps to develop into a complete and independent adult. So as we all know, carrots and sticks are essentially rewards for compliance, which is the carrot, and consequences for non-compliance, which is the stick. And we can use all sorts of provisions that are both carrots and sticks when we're doing our estate planning, right? And it's really dependent upon perhaps how much you've allowed the client, right? How much runway they've had. Maybe you've given them multiple carrots and you're ready for the sticks at this stage, or it's just really guidance because you don't know if you're going to be there through their developmental years, right? For those of us who are planning for kids who might be 4 and 8 years old, for example, we don't know what problems lie ahead, but we want to encourage them to make good choices. So we're going to be talking about sort of both of those approaches, and everybody can pick and choose how they see fit. Now, I always remind my clients, we cannot control the actions of another, but we can at least keep control of our money after we die if it's held in a trust. And that's one of the unique benefits of a revocable trust, is you have the ability to uniquely design how that money is accessed. Whereas if somebody drafts a will, it's going to be operative when they die, and it's simply going to just distribute at the end of the probate, right? No conditions, etc. So the hope is that the financial assistance given through these carrots, or maybe the financial loss, if you're using a stick approach, is going to motivate the children to develop in the right way. All right, so let's take a look at what do we mean by incentive and punitive provisions. So incentive provisions would be something along the lines of a reward for what's important to you as the testator, right? As the person putting the trust together for their family. And maybe rewarding what's important for the child or for the other beneficiary, right? You could give them a reward for what their biggest challenge has been to overcome. Now, what do I mean by big challenge? It could be sobriety. It could be dyslexia. Perhaps the child has had a lot of academic challenges. They've never been able to complete their formal education. So really drafting in a reward for them to have achieved that goal would be something that would be an incentivizing provision. And then rewards for achieving what the children need the most, right, to make sure they're independent. And then last but not least, reward harmony. And, you know, we can put amorphous language, and we're going to get into some examples of that in just a bit. But, you know, rewarding harmony can also be concrete. So oftentimes trust distributions, I would recommend be withheld for a certain period of time if there is a known conflict between the children, or between the trustee and the children beneficiary, or even between, you know, maybe two cousins who don't get along, right? It doesn't always have to be our kids. And how we would do that is we would allow for a distribution only after the statutory period has passed for them to challenge the trust. Or we might want to consider doing something along the lines of another incentivizing provision for not suing the trustee, maybe after 2 years. You know, so we can always draft something in to really have it impact them, right? Outside of just the standards of the law, and really within the mechanisms of the trust itself. So that's easy to do, and if we have a known problem on our hands, we're going to offer some solutions like that are, you know, frankly, creative solutions to avoid litigation. Okay, by contrast, we've got punitive provisions. So punitive provisions are punishments, basically. So punishing for bad behavior, for failure to meet benchmarks, and maybe to failure to work or to support your family. Those are all punitive provisions that would be considered a stick. And the reason these concepts are broad here, you know, bad behaviors and so on, is because each family has its own values and unique family members. And the benefit of drafting with an attorney, especially an attorney who's been an estate planning attorney for a number of years, is that they're going to provide a lot of ideas as to how to solve a particular problem or how to address a particular issue. And that is something that, you know, I've been doing this 18 going on 19 years, and I don't want to say I've seen it all, because I'm sure I'll turn the corner and be surprised, but I've seen many struggles, and at different degrees as well. And so what I love about working with clients and really customizing and drafting a trust for them and for their family is having them lay these issues on the table and saying, you know, I've seen clients do this, I've seen the clients do that, I like this provision, and really giving them the whole, you know, kitchen sink of options to deal with it. And so, you know, after 18 years, I really want to make sure that I help facilitate the advancement of their children's development and not stagnation, because I have seen, and not just in one case, but, you know, I would venture to say in many cases, inheriting before somebody's fully developed. And I don't mean not supporting a child, but I mean, you know, a large principal distribution coming their way before they're fully developed can really be catastrophic for their development. It's hard to be motivated when you know all of your needs are met, and probably some of your wants too. And then by the time they realize that, you know, they're not standing on their own 2 feet, are they now 45 and unable to really take it to the next level of development? So, you know, this is sort of my version of do no harm, right? We can assist them, but we don't want to supplant their independent growth. Okay, so let's kind of jump in and look at what the heck am I talking about, right? What are these carrot and stick provisions? And so, you know, I decided to use education provisions because that's something pretty commonly of concern of my clients if their children are, or maybe grandchildren are, you know, under the age of 25. Because again, a lot of times estate planning will be initially for the kids, but parents might revisit it as their children, you know, are 40 years old, 45 years old. They might start to have a grandchildren share, right? Or maybe they bypass the children altogether and it's all for the grandchildren. Or for those of us who don't have kids, you know, there are a lot of other beneficiaries who might need their own sort of customized carrot and stick provisions. But for now, let's go ahead and look at the education provisions. And this says, you know, and by the way, for education, when you're doing this with an attorney, you get to define what education is. You know, you can say formal education at a 4-year university, or you can say vocational school. You can define the GPA, you can define the amounts of distribution, because of course, this is all relative to the size of your estate, and it's relative to what the beneficiary has as well. So looking at an example here, it says during college, our trustee may make discretionary distributions for each beneficiary's tuition and modest living expenses, as well as healthcare costs such as health insurance. And then you can go on to further specify, provided that they have a 2.5 at all times, or provided that the beneficiary demonstrates a diligent effort as viewed in the trustee's sole and absolute discretion. Right, and so again, these are developed over time. I know I had a client recently saying, look, a 2.5 at, you know, School of the Redwoods, right, a community college, versus at Harvard is not equal. And I don't want to have this black and white provision that may not apply to that particular child and their abilities. And so, you know, we worked something that just said diligent effort, right, in the view of the trustee. And so, again, this is really a conversation that you can have to ferret out exactly what the client's really trying to achieve and making sure that the language matches that. And then, of course, you'll see on the very bottom of that carrot side of things, it says in the trustee's sole and absolute discretion. And when we have anything that's not a very black and white 2.5, we want to make sure that we include language that says something along the lines of within the trustee's sole and absolute discretion, because what we don't want to have is any vagueness, right? We don't want to have a vague and ambiguous term that might result in the beneficiary and or the trustee wanting to seek court interpretation of the language. And so by adding in these magic words of trustee's sole and absolute discretion, we've gone ahead and really taken the mystery out of it and just said the trustee decides what diligent effort is. So that can be a good thing and a bad thing. And again, we really want to sort of gauge it and evaluate who that trustee is too. So going across to the other side of the slide, there's the stick approach, right? So let's assume somebody has $400,000 set aside for education, which will buy you what, one semester these days? And this says, should a beneficiary not graduate from college by their 25th birthday, the undistributed graduation distribution of $400,000 shall be donated to a 501c3 charity. So that's pretty punitive, right? And maybe maybe they've already tried multiple times with carrots and it didn't work. And so they really want to make this a use it or lose it proposition. And that's okay. But, you know, obviously it's a lot more severe than the carrots here. Or something as simple as, yes, well, the trust will pay for your school tuition and support you during college, but if you drop below a certain GPA, that's it, right? And you can work in certain provisions about how they might get back into your good graces, right, after they failed during one semester. So again, we would customize language for that. Okay, so now let's look at a different type of distribution, which would be for hitting benchmarks. So oftentimes when we draft a trust for people who have, you know, they may not be extremely wealthy, but they want to make sure that their children are not squandering money at the age of 20 or 25. It might very well say that everything is held in trust until that child is 45 years old. And in the interim, we want to say how that child can access that money, because if you pass away and that child's only 17 or 25, do we really want that money to just sit there for a period of years? So a lot of times people will draft in benchmarks that really have to do with their values, right, as a family. And so looking at the first one, purchasing a home, which is, you know, a very big one, and it's understandable in the state of California why people need help buying a home. It's extremely expensive, especially as of late. If you were alive, this might be something you'd want to offer to your child. And just because you're not there doesn't mean you shouldn't be able to provide them that financial assistance. So here this says, basically, regardless of age and upon the beneficiary's request, the trustee may distribute up to 20% of the beneficiary's share. And then we can cap it at a number if we'd like. And we can say for purchase of the principal residence, it could say for the first principal residence, it could say for investment property. And then we have other ideas below saying perhaps so long as their income qualifies for the mortgage, which makes perfect sense. Or we could say so long as they've saved up. So if they saved $100,000 for a down payment, then the trust will match that. So again, we're incentivizing these kids to kind of do right by themselves, and then the trust is backing them up. Similarly, with saving money, if a beneficiary declines to have anything more than, let's say, income beneficiaries or income distributions from the age of 21 to 25, then he or she gets 25% of their principal at 25, right? That's a great tool, because it's basically teaching delayed gratification, putting in the hard work now, seeing the results later, something I think a lot of the kids these days have a very difficult time understanding. Maybe I need to do a TikTok on it and they might understand it in their language, but all sorts of ideas like this. And then there is an option to have a pooled account for children. I have seen this happen and I don't always like it, because it could put the kids at odds where they're competing for the same pool of money. And, you know, maybe it makes them very driven, but if it destroys the sibling relationship, then, you know, in my view, it probably defeated the whole purpose, right? And so I just want to be very conscientious if we ever have a pooled account that kids are competing for with benchmarks. But it is one way to drive them, certainly. Stable work is another one, right? If at the end of the year, the beneficiary shows that they've been working, the trust will match their income by 50% at the end of the year. Not a bad deal, right? But this is great for people who just have had difficulty really getting into the workforce and staying in the workforce. And then another way is just after the first 6 months of full-time employment, they get a principal distribution. So all sorts of different things. And, you know, all of these terms that we're looking at, they sort of sound like conversations a parent would have with a child, right? I'm sort of thinking over the dinner table and negotiation, so to speak. Hey, if you do this, I'll help you with this, right? And I really do think that these benchmark incentives reflect those kind of parent-child conversations, or maybe grandparent-grandchild conversations. And if we're not here to have those really detailed guiding conversations with them, then our trust at least can speak for our values, right? And financially support those concepts. You know, I won't go into any more detail on benchmark incentives, but One other quick example I'll give you is clients who are entrepreneurs often want to see their kids start a business, or at least have the opportunity to start a business. And you might say something along the lines of, I want the trust to provide seed money for a business if a business plan is drafted by the beneficiary and submitted to my first business partner, Sam Smith, right? And we do that because now we know Sam Smith is tasked with kind of stepping in as dad or mom, and sort of having that mentor relationship. Sam stamps seal of approval on the business plan, maybe after some modifications, and then sends it back to the trustee, who then provides that financial support. So the world is really your oyster, right? If you bring to the conversation, these are the things I really want for my family, then these are solutions that can be offered by a seasoned estate planning attorney. Okay, the flip side of that coin is dealing with problems, right? And here you can see I'm not going to read it for you, but very detailed protocols on testing and hair follicle tests specifically, and how many hours you have to wait. And I mean, you can see this is addressing an actual problem. And that's okay, because that could be extremely important in the face of an actual addiction. One of the greatest stories I have or moments I should say, as an estate planner, is a mom of a grown child who came to see me. And this was a couple years back, and she was a new client for me, and she brought in her old trust, and she said, yeah, I need to make some changes to my trust. And, I've got this drug addiction language, something similar to what we see here on the screen. And she said, my son was in a really bad place when I wrote this trust. He was a really down and out addict, and I thought he wasn't going to live much longer. His addiction was so bad. And I knew if I died as my only child, if he had access to money, it would kill him in a matter of months. And so she had all of these very protective provisions put in, because that's the last thing we want to do as parents, is harm our children. And 13 years later, here she was saying, well, he's married, he has a child, he's a successful financial planner, and I want a new trust entirely, because I don't want to shame him with really having to revisit these ugly years of his life. And so, typically we would just amend to strike this language, right, and replace it with something else, maybe a little bit lighter, or just leave it out altogether. But in her case, she didn't even want him to see it or know it ever existed. So we had to do a whole new trust, and sort of, that way we didn't have to look back at this document. So, this is, again, it's a necessary evil if we're facing a problem, because we want to protect our children. So there's all sorts of language like this for gambling, sex, drug, alcohol addictions, you name it. And, we can sort of put in a protocol for the trustee to really use to protect that child. All right, so let's compare that to the next slide, which is, this is really a hypothetical concern, right? Some preventative language, foot in the door for the trustee if they need to be protective in the event an issue arises with drugs or alcohol or something of the like. So we want to put something like this in here if maybe you have a distant uncle who's got an addiction problem, or maybe you're just a nurse and you've worked in rehab, right? And you don't want to just ignore the issue, but you don't need to cite or write the Magna Carta to deal with the issue. Something like this at least just allows the trustee to take steps with testing, and we've got everything in between. So again, some people might want to put this in for a 4-year-old who absolutely is not going to have a drug addiction, right? But just in case it develops in the future. Okay, now, we've talked about some really specific nitty-gritty clauses for specific issues. But again, we don't always have to address specific issues. Sometimes we are just trying to provide a flavor of our value system. And, this works because probate courts are a court of equity. And that means they're always striving above all else to meet the intent of the person leaving the money behind. So having their intent reflected in the trust by literally a section called Testator's Intent, or putting these guidelines, right, for distribution that are a little more amorphous, works well to send a message to the beneficiary as to what's important for you, right? Almost as if it's a letter of kind of your dying wishes or your aspirations for that person. It does the same thing for the trustee, who's going to have that discretion to decide on some distributions if you've designed your trust to have discretionary distributions of income or principal. And so it's an important step when particularly we have, you know, young children. We don't know what things are ahead of us, right? We know we need a trust, but we want to reflect our values, right? I really want my children to get an education, or I really want my children to get a car when they turn 16, or to be really active in sports, or to continue their passion for piano. Whatever it is, we can include that in that in general, and then in that particular beneficiary share, so that the trustee has some sort of a guidepost as to, you know, what you'd like to see. And here's some examples of that generic guideline, right? It's now again, this is not black or white, right? How do we specify whether somebody's acting with empathy or thoughtfulness? We're not. We're sending a message, but you know, I would only leave it to these generic guidelines if I had, you know, a twin sister who, you know, almost read my mind and knew exactly what I was thinking and what I meant by these things and how I would sort of translate this into concrete, this means empathy, that means thoughtfulness, and so on. To leave it just like this, again, if you've got those two PhD 40-something children that are well on their way, you know, you really don't need to concern yourself. Maybe just sending a message like this would be nice. But if it's something where you want to really be giving black and white instructions, a blueprint, then you want to stick with the specific provisions like the ones we looked at earlier. Vague guidelines like this also, again, you really need to closely evaluate who your trustee is, because that trustee has to have the strength to interpret this and to stand up to beneficiaries when they disagree with your interpretation, right? And so these are not what I would, you know, I would coin as contract provisions, right? Like a lot of other provisions are in a trust, more or less. So let's go ahead and kind of visit the idea of difficult beneficiaries. We all remember Veruca Salt. Let's take a quick look.
Hey, Daddy, I want a golden goose.
Here we go again.
All right, sweetheart, all right. Daddy will get you a golden goose as soon as we get home.
No, I want one of those.
Wonka, how much do you want for the golden goose?
They're not for sale.
Name your price.
She can't have one.
Who says I can't?
The man with the funny hat.
I want one. I want a golden goose. Gooses. Geeses. I want my geese to lay gold eggs for Easter. Hey,
Oh.
Daddy, I want a...
Super fun. All right, if we've got two situations here, right? We either have a Veruca Salt, or we see maybe the seedling, or we don't want to see the seedling of a Veruca Salt, right? So we need to make sure to set up our trust to ensure that we're not encouraging this type of behavior. And if you know you have a difficult beneficiary on your hands, and you know that they're going to push the envelope, we don't want to rely on health education, maintenance, and support unless you are rock solid in your choice of trustee, right? Who is ultimately, in many cases, the way these clauses are drafted, the grand interpreter, right? The interpretation begins and ends with them. Because again, our goal is to administer the trust without needing to go to court, either for interpretation or, God forbid, for an actual conflict, right? A trust petition against the trustee, or other litigation in probate court. And so you need to really ask yourself, as you're designing these provisions, who is the enforcer, right? The shepherd of really implementing these. And what I mean by that is your trustee. You've got to pick a trustee who knows you and your value system, right? Or you need to just be black and white as to what those benchmarks are. You need to pick a trustee who have clear boundaries, and particularly when you're saying it's in their discretion, because if a Veruca Salt is having a temper tantrum, are they going to give in, right? And are they going to do what the beneficiary wants because they're alive to bother them and make their lives miserable? You're not, right? So we need to really think through that. And if you pick a relative, do make sure the terms are black and white, so that perhaps you have one sibling looking over the share of a younger sibling. I don't want to ever pit those two against one another, because above all else, we've got to maintain the health of the family relationship. And if it's really going to be difficult because of the terms of the trust, or because a beneficiary is just difficult, and we all know we have different family members, that's something that should be discussed with your estate planning attorney, so that you can perhaps consider using a professional trustee or a corporate trustee like a bank. So that will really sort of help ensure that all of the trouble you're going to design a trust to facilitate growth in your children and to distribute money in the way you want to see it distributed comes to fruition after you're gone, right? And that trustee choice is huge there. So make sure you're looking at that and making good choices with that. So with that, I think I'll just turn it over for questions if anybody has any specific questions. Radio silence. It must mean I'm crystal clear and everybody's drafted their trust as we're speaking.
Noelle, this is Charles Cooper.
Hi, Charles.
One of the things that this came up for me because private wealth management, you and I have talked about my career over the years. In fact, we were right across the hallway from each other for a little while. But one of the things that I guess I got away from was encouraging families to use a relative, just because of the emotional part of it. I thought it was much better to have somebody that is either the attorney's office, the trust company, something completely away from the family. It seems that it's worked out much better in the cases that I've had.
Yeah, absolutely. I mean, some families are just adamant that it remain in the family, and it could be because of voting stock at a corporation. I do a lot of estate planning for people who have closely held businesses, and that's a real concern for them. There are ways where we can skin that cat, right? So the voting is in the hands of one person, and the other tasks are in the hands of another. But you know, that a lot of times there's resistance. I think if there's any chance that a trustee is going to be put in the line of fire, you know, better to leave it to a bank or a professional who has their career is basically been dealing with those situations, and they have solid advice and whatnot to make sure that they do everything the right way. You know, so again, it's something, if there's going to be a conflict, or somebody is not going to be able to stand up to or if they just don't have the sophistication to be able to manage these assets, right? Because it's all relative. If you have a $25 million trust, it's a whole lot different, and different group of assets and different volume of assets than a trust might have $1 million in it, you know, with one home and maybe a bank account. So I agree with you. You want to do whatever it takes to maintain peace amongst the family. And if that's bringing in a corporate trustee, I think that's a really small price to pay.
Right. It was the advice I gave my parents. They asked me to do it, and I go, no way. I go, I'm not dealing with my oldest sister.
Yeah. Well, and again, if you know you have a problem relationship or a potentially problem relationship, better to steer clear so you have somebody to spend Christmas with. So it looks like we have a kind of a similar question is, are you able to incorporate foreign assets in the trust? The short answer is sometimes, but typically it really is dependent on the overall tax situation, right? And so you have to look at what kind of assets, where they are, which country they're in. One of the big questions I always have, and I always have to enlist the person's CPA and maybe even advisor in the other jurisdiction, is where are these assets being reported? And real estate in particular, it's extremely difficult to do that. And then the other question is, it looks like there's a couple. There's a question from Claudia Parker that somebody else did a follow-up question to. How do you go about choosing a corporate trustee for a smaller trust? You know, it's challenging sometimes. So that's, I think, really private professional trustees do a good job of filling that gap, right? I know many corporate trustees, typically banks are, at least $5 million or more of assets that they need under management in a particular trust. Now, if they have a bigger relationship with that client, it's not necessarily a cliff at that number, but I think it depends on everything else that they have involving that family. And so a lot of times people don't have $5 million, and there are some banks that I think do it at 3. But what if you have a client at 2.5 and everybody they know, lives in China, right? I often have where they have no family here. All they've done is work here for the last 15 years and they need someone. So a private professional would probably be that stopgap, right? Who they tend to be a lot more flexible with the number of assets and the value. And then the follow-up question to that was, what does something like that cost to administer the trust? So, it's all relative, the trust size and how long it's going to be administered. And so all of these banks and professional trustees, they have fee schedules. So what you're signing up for when you get involved. Of course, they update those, right? Just like a law firm would update the hourly rates from time to time. They do the same thing at trust companies and with private professional trustees. But, I always tell people, it may not be more expensive than what you're going to pay your child or, another family member, because typically it's reasonable compensation. And again, that depends on the size of the trust, but your kids are entitled to 1% of the trust res, kind of a default number per annum. Right. And so then they're going to hire a lawyer, then they're going to hire a CPA, and they're going to have, because they're going to be lost without that advice in all likelihood. And factor in the costs of the lawyer and the CPA, whereas a professional or a bank, they're still going to have counsel and they're still going to have a tax advisor, but a lot of the basics they already know how to do without that extra assistance. So it's definitely a conversation to have, and usually your trust attorney can kind of get you going in the right direction, really get a sense for what do you have in your trust, how complicated is it, and maybe think of at least a corporate trustee or a professional trustee alongside a family member, right? So one's the technician and the other one is kind of reaching out to the family. So there's a million ways for us to do it, but it can, I always tell people, they say they don't want to take trustee fees, but after they've taken all their vacation time, they end up working nights, doing spreadsheets, they gather documents and distribute them to 20 beneficiaries. They say, God, I had no idea I was going to miss that much work or how stressful it would be. So I do remind people, the trustees tend to want to take that compensation because they end up losing money and time. All right. And any advice for making the younger of 2 siblings the trustee? It depends on the family, right? Some children would be devastated by that, but others, I was just meeting with clients not too long ago, and it was like, yeah, of course it's him, right? Because, he was the guy who did the financials, and, the other one was a little more artsy and really had no desire. So, again, we have to have that conversation and figure out if it's really going to be stepping on someone's toes. And by the way, we have some other positions we can fill with that other sibling, so everybody feels like they're, being treated equally or not excluded at least. So, again, we're trying to be conscientious of keeping the family copacetic. And then a corporate trustee versus a private trustee. Yeah, so a corporate trustee, again, is like a banking institution, typically a trust company, right? So these are big entities. A private is simply an individual, right? So it's an individual who is a fiduciary, a licensed fiduciary in the state of California. So different. It's a one-man operation. Typically, they plug into groups, but you're talking about you're hiring a person. You're not hiring a bank. A lot of questions about the trustee. Anybody else have any questions before we end? And we did record this and we are going to post it if everybody has any sort of follow-up or wants to see the slides.
So I have a question, Noelle.
Sure.
If I have a special needs granddaughter, should I incorporate something special for her in a family trust or make it a separate trust?
No, I see no reason to make it separate unless you're funding it now and it's going to be a live, irrevocable trust that you've transferred to. Typically, our families that have special needs family members, they will do their trust, their regular revocable family trust. And then let's say you've got 3 equal shares, 2 of them might go outright to, to your children at the age of, let's say, 35. And the third will be for that special needs person. And basically it'll be managed in that special needs trust, but the money gets dropped into all 3 buckets at the same time. The difference is it comes out of the other 2 buckets versus being held in a special needs trust for that particular child, so they don't lose benefits, and basically it's they're being watched over for them. Okay, it looks like we have one more question. Just because we love them doesn't mean they're equipped. It looks like just a comment. Yeah. Good. Well, I hope this was useful for everybody. I know it's something we all worry about and sometimes actually struggle with. If you have any follow-up questions, my email is right there on that final slide, and I'm always available. Thank you so much and have a great day.